These five Cameroonians made their way into Nigeria and boarded a plane that was bound for Antigua through assistance of a church that was supporting them. And from Antigua, they made their way into Grenada, then in transit into Trinidad and Tobago, and then on to Suriname, where they had visas for. They were denied access into Suriname and returned to Trinidad. Upon re-entry into Trinidad, they made an application to the immigration to consider whether or not they could be allowed to stay. They require visas to enter into Trinidad, but Trinidad, having a UNHCR office based here, they sought to have the intervention of UNHCR to consider an application of whether they could be deemed to be refugees or not. An emergency hearing was held by immigration, a special inquiry. I appeared with a team of lawyers to represent these five Cameroonians. It was refused by immigration. An appeal was made to the minister. Again, that too was refused. But one of the requests made was for UNHCR to actually be facilitated to interview these individuals. And we were able to get permission while they were detained at our immigration detention center to be interviewed. The UNHCR completed interview of three of the individuals who are women on the 10th of February. The two others, the two men, the father and son, were meant to be interviewed the following Monday. But on the 11th hour of a determination of these matters, immigration sought on the 11th, a Saturday, to take them to the airport hotel close by and inform them that they'd be deported right back to Cameroon. This was very distressing for the Cameroonians, largely because they were engaged in a process of being interviewed and assessed by UNHCR to determine their status. And there was full cooperation with immigration and attorneys. And one would have expected that there would not be the intervention of deportation with this pending determination of UNHCR. Efforts were made on the 13th and 14th to reach immigration, but there was very little communication between attorneys. In fact, I was deprived access to my clients to have any communication with them, but they managed to still communicate with us to provide limited instructions. On the 14th, we were provided with information from UNHCR that they had completed the interview, assessment of the three women, and deemed them to be official according to the UNHCR. In spite of this being communicated to National Security and Immigration, the decision was maintained to have them deported. And with that information and information coming to hand that they were likely to be boarding a flight on the 15th of February at 3 a.m., an application to the High Court was made late on the 14th of February to seek injunctive relief. Fortunately, the court granted an injunction restraining immigration and national security and the airline from having these individuals sent back to Cameroon. It was almost after midnight the order was granted, and these individuals out to board the Copa flight, and they were able to be retracted from the flight, and the injunction was able to take effect. Subsequent to that injunction, we were given permission to actually have access to our clients, and UNHCR conducted their further interviews and deemed the father and son to also be refugees. When the matter came back up to court on the 16th for further hearing, where the state was represented, a decision was made to allow the injunction to continue until the full determination of the matter. So the five Cameroonians have been declared by UNHCR to be official refugees. And the matter now is before the court. UNHCR has the power to relocate these people to a different country if they choose to do so, a country that is minded to, through partnership, to take people who are deemed to be refugees and have certain circumstances. That's a process that is underway. At the same time, we have an application before the Minister of National Security where exceptional circumstances occurs. In this case, we give special consideration to our clients who are all now declared to be refugees. So we took a decision to represent these individuals who required assistance. It's a human rights case, and we felt it was something, especially when one considered the circumstances of their story and their journey from Cameroon and what they had to go through, it was a case that warranted our intervention on a pro bono and a no-cost basis. We have to accept that the world is a rapidly changing place in terms of immigration. We're seeing all sorts of developments taking place, and most of our legislation, particularly in Trinidad, is outdated, and it does not treat with the development that is taking place. Trinidad, we have problems with Venezuelan immigrants. You in Antigua having the problem with the Cameroonians. But we can't look at this and just rely on archaic laws. We have to look at how do we develop the law? How do we put policies in place? How do we treat these individuals who are not there as necessarily visitors or by choice? They're there out of necessity. And the law must mesh with some degree of a humanistic approach in developing how policies are put in place. And eventually the law is amended. We must always bear in mind, most of us in the Caribbean were not brought here. Some of us are here by choice, but we're all immigrants one way or the other. And we should be mindful of people who have difficult circumstances ought to be treated in a like-minded manner with a high degree of compassion. And the law ought to operate in that fashion.